Give me 1 second.
Sure thing.
I don't think we're officially on it yet.
Okay.
Okay, we're on and you're good to go.
Okay, thank you. My name is Ellen McLaughlin, and I am a licensed attorney in the state of Washington, and I've been practicing family law for, I think, 21, 22 years. What I want to talk to you about today, what I've been asked to talk to you about today, and maybe help you guys out with non-parental custody cases and filling out the documents. And what's happening is, that makes this important right now, is RCW 2610, which that chapter of Title 26, which is mostly all of our family law statutes, that is now, it has been repealed, and it's no longer going to be in effect as December 31st, as of December 31st, 2020 at like midnight. So come January 1, all of the forms, those statutes are not going to apply anymore. So what's going to happen is there's a new chapter coming in, RCW 11180, and that's regarding, that's been called by the legislature the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act. So that that new act is going to really take over the role of the non-parental custody cases. So to close your non-parental custody case, I'm going to talk about the major forms that you'll need to fill out and go over them with you. I don't know everyone's situation in the audience. I'm not sure whether the person that I'm speaking with right now is a grandmother, an aunt, whether that person, whether you are the biological parent.
Okay, sorry. Are you talking about? Okay, I could not hear you because I didn't have my volume up on my computer.
So, so I'm going to just go through these forms and just let you know how to fill them out. What you're going to do is you're going to fill out what's called the Yakima County Clerk's Office Domestic Ex Parte Cover Sheet. And this is the cover sheet that you can find on the clerk's website. I'm going to hold it up so maybe you can see it. I don't know if that helps. Kind of, it's not showing the right way, but anyway, it's the Yakima County Clerk's Office Domestic Ex Parte Cover Sheet, and this sheet is what you're going to put on top of all the other forms that you fill out, and you're going to hand this sheet in with all the other documents that we're going to go over, and you're going to hand those into the clerk's office. This ex parte cover sheet can be found by going on Google, and if you go on to you Google Yakima County Superior Court, that will get to you. Then you would get to the clerk's office page, and then you Google in that website, in that portion, you would enter ex parte cover sheet, and so that's how I was able to pull it up. It's pretty easy. You may already have this form in a binder that you purchased with the county. This sheet, it has a place for the petitioner to write their name, and if you are the petitioner, you fill out your name there. If you are the respondent, you would fill out your name there. So you basically are going to look at your caption for the your cases that you have. You'll probably already have your case, one of your pleadings in front of you. So you go to the caption and you would fill out, there's a place where it says petitioner, and you put the petitioner's name and then respondent's name, and then you would also put your phone number. You being the person that is asking this, asking the court to sign your papers. So you're going to put your number there, your telephone number, a cell phone, place where if the clerk needs to reach you, she can, she's going to look straight to that number and give you a call. There's also a box for an email, and you can put your email in there as also. I recommend putting both in there, and make sure that you write clearly the phone number out and the email. It's very important to be able to read the numbers. A lot of times when you're writing really fast, nines can look like ones, and fives can look like eights. So take your time. I know that might sound too basic, but it has happened where the numbers are just written so fast you can't tell, and the clerk can't reach you. And the same argument goes with the email. Make sure your email is written out really carefully, slowly, so that people can read it. So that is the basic information. Now, the next box on that form, they ask you what efforts have been made to notify the other party. And there are, depending upon the situation that your particular case is in, your answer is going to be really, under these situations, going to be none. You're not going to give them, you're not going to write down that you have notified the other person. If you have put down, you just fill it in. Yes, I notified name the other party, the other person, I notified them yesterday by phone. This is a number I called, and I gave them a copy of all the documents. Now, there are situations where you don't have to notify the party. And really, when it says ex parte, that's what it means. It means you don't give the other party notice. But under some circumstances, you may want to give them notice. And so that's why there's a box there for you to fill that in. So then what I'm going to do next is we've finished up with the Yakima County Clerk's Office ex parte cover sheet. And again, please don't forget this. This is you've got to have this form filled out with your documents. The next one that we're going to talk about is default. And I'm going to talk about what we do to take a default in your case. The first form that I'm going to show you and talk about is Family Law All Family number 161. And if you have your folder, your binder, the motion for default is in that big packet of forms that you have. And again, it is Family Law All Family 161. That is, so it's 161, that's the number. So for the default, you're going to fill out 2 documents. You're going to have your motion for default, and you're going to have an order for a default, because you want, when you file the motion, you want your motion granted, and the only way to get it granted is to make sure the judge has a copy of an order to sign. And you're going to provide that piece of paper, that order, for the judge to sign. So for a motion for default, two documents again. It's going to be the motion and the order. The order number is all family 162. So it's number 162. So you need 161 and 162. Those two documents. Now, I just want to briefly, before we go into the document, just talk about how a motion like this would arise, and that it would be under a situation where the non-party has filed this non-parental custody petition, and they had the other person served, and there has never been a response filed by the other party. And what I mean by a response is there's a number, there is a specific number of a form that the person is supposed to fill out that you serve. So if you're the petitioner, you have to serve your petition on the parent. And so the parent, if the parent does not file this response, then you have, it's 20 days, you wait 20 days. If that 20 days have passed after the time of service and the parent has not filed anything written with the court, then you would go ahead, you would go ahead and get your motion for default prepared along with the order and submit it with the clerk's office with the ex parte cover sheet. Now, that is again a situation where the other the parent has not responded. There has been, there's nothing that's been filed. There's been nothing that you've received from the parent. So let's first talk about the motion, and this is pretty easy. Make sure you have your petition in front of you so that you can refer to certain dates, so you can fill the motion for default out. There's a place for your name, just write your name, and then that was number one. Number two, you request the court to find the other party, and you would put the parent's name in there, which would be also up in the caption, the respondent. You would put their name in there, and it says, I ask the court to find the other party, parent John Doe in default, and to approve final orders in the case. So that's pretty easy. Number three is, this is about notice, and this is the situation where you filed your petition and the parent has not filed any notice with the court at all, hasn't filed any response rather. They haven't done anything. They were served and they just did not respond to the lawsuit. So you would, for number three, you would check, you move to page 2, and on the top, you check the paragraph or the box that says, I do not have to give the other party a copy of this motion and advance notice. So that's because the person's never responded. So you check that box. Now, number 4, the judge wants to make sure that the other party was served properly, and they know that this case was filed. So what you want to do on number 4 is put the date when the parent was actually served. You want to put that date in there, and the judge is going to look at that date and make sure that it's been more than 20 days that have passed that will be the reference date that the judge uses to make sure 20 days have passed so he can sign your order that you prepared. And then under paragraph 4, it asks you, if there, what state, if it was a different state, and if you had the other party served outside of Washington, you would just explain why you had to serve them out of Washington. Say, well, they don't live in Washington, they live in another state. Number 5 is the timing and the type of service. Personal service in Washington, that's an easy one. You will want to have personal service unless you got an order that allowed you to serve them by mail. So we're going to assume that the parent was served, and so personal service in Washington or personal service outside of Washington. So you've got 2 choices there. One, and it says at least 21 days ago. For this inside the state of Washington, and then service outside of the state of Washington, you have to give the other party, they have 60 days. So if the person you served lives outside of the state of Washington, you can't take this default. You can't file this motion, and the judge won't sign the order for default if it's only been 30 days since they've been served. So make sure that if you have served them out of state, you've given them 60 days. And that's, and it says here, actually, they're using the number 21 and number 61, but it's really the same thing. You're giving that person sufficient time, the 20 days. So in Washington, you check 21, out of state, you check 61. The number 6 is the venue and jurisdiction. This is where you just fill in the county and the state where you live, and the county and the state where the non-parent lives, and also where the children live. Okay. And number 7 is for active duty military. If you are not active duty, and the other party, the parent isn't active duty, you just check, I'm on page 3 now, you just check at the top there, the other party is not covered by the state or federal Servicemen Civil Relief Act. Now, moving down a little bit further on page 3, if the parent is in the military, then you have to check the box that says the other party is covered by the Federal Servicemen Civil Relief Act, but and we're working under the situation where the parent hasn't filed a response, so you would X that box that person, that parent, mother or father, did not respond, and they're active duty. And again, if they're active duty and they're out of state, you want to make sure that 61 days have passed. Okay, so at the very bottom of page 3, you want to make sure that you sign your name. It says signed at the city and state, so you'd put signed at Yakima, Washington, and you would put the date, that today's date, and then you would sign your name, and then next to your name you would print your name. So that's the motion for default. When you fill this out, make sure that you've got the correct case number on your caption. The caption is the very top part of your form. It contains the name of the court, and it contains the names of the parties and the case number, as well as the title of the court document. So once you've got that filled out, then you're going to go to your order on motion for default, which is all family 162. That's the number for the form. And Again, make sure you've got the caption filled out properly. And number 1 says, the court has considered the motion for default filed by, and then you fill your name in. And then moving to number 2, the other party, you put the parent's name in, and you would check has not filed a response to the petition. And number 3, notice about the motion, under this paragraph, and under the situation that I've started with as an example, we're assuming that the parent never filed any kind of response to your petition. So you're going to check the box that says is not entitled to notice of the motion for default because the person's not filed a notice of appearance or has not responded in any way whatsoever. And that they were served a copy of the summons and petition. And also regarding the timing, paragraph number 3 makes a good point. If it's been more than a year, there's you don't have a legal factual basis to go forward with this motion for default, which means you'd have to start everything all over, and you would have to start the case over under the new statute, under the new guardianship law. So a motion for default can only be filed within a year. So if it's been more than a year, this isn't the right motion. Okay. So under 3, you have these 3 options. You have that the person is entitled to notice. The second option is not entitled to notice. And the third option is notice was given even though it wasn't required. So you basically fill out the box that's appropriate. Okay. So number 4, the summons and petition. You want to check the box that says that the parent was properly served, and you put the date on there that they were actually handed the summons and the petition. Okay. Number 5, timing and type of service. You would check the very top box, the other party was served with the summons and petition by, and then you have these options to check. And again, it would be personal service in Washington, 21 days have passed, personal service outside of Washington, and 61 days have passed. And if you have, if you did get an order that allowed you to serve by mail or by publication, you would check the appropriate box there. The number 6 says you want to check the box that says the court has the jurisdiction to make this ruling, to enter this order over in this case, and that the venue is proper as well. So you check the first box. And on number 7, again, we're back down to the active duty military. So again, this is part of the order, and you want to fill out, you want to check the box that's appropriate, whether they are on active duty. You would check the second box, which says they're covered by the Servicemen's Civil Relief Act. And then you would check the reason why the default's appropriate. And that's going to be because, they haven't filed a notice of appearance or filed any kind of response. But your first option there on paragraph 7 is the other party is not covered, is not in the military. So if they're not in the military, then this federal law, the Servicemen's Civil Relief Act, doesn't apply, so you check that box. And keep in mind, this order really, it mirrors your motions. So so as you're filling out the order, you can basically go back to your motion document, family law all family law form 161, and you can go back and look at the motion, and you're basically just going to put the same information on the order. So let's see, we're almost done with this one. So we go to we're on page 3. Number 8, other findings. Ordinarily under this kind of situation, there's not going to be a need for anything. You can leave that blank. Number 9 is you're going to check the court orders, the granted, the motion for default is granted. And so you're going to check the box granted, and you're going to put the other party's name, the parent's name there is in default. Okay, so, and at the very bottom of page 3, on the order, on motion for default, make sure that you sign your name and print your name as well, and check, whether you are, check that you're the petitioner. So that's a motion for default. Now, it's right now, we're getting pretty close to the end of the year, and so the only way you're going to get a default is under these facts that I just described, and that is that you have filed your petition and the parent has just not responded at all. So moving along, we're going to now fill out two documents that are really important that you have to fill out, and it's the first one is called the Findings and Conclusions on Non-Parent Custody Petition, and that is non-parent form 430. So it's 430. So you have to fill this one out, and this is assuming you've got everything you need. The judge is good to go with your order for default. So he's going to sign your order based upon your perfectly filled out motion for default. After he fills out the order, he's then going to come to these next two documents. Again, they're important. It's 430 and 431. The Findings and Conclusions of Non-Parent, which is 430, and then 431 is the final non-parent custody order. So these two have to be filled out before or along with, you want the one that's the most important for you, I'm sure, is the residential schedule. So, and this is the reason why you filed this petition, is that you wanted this final residential schedule, which is sort of synonymous with the parenting plan. So before we go into those other three documents, I just want to review. So it's five documents with this motion for default, so that you can get the relief that you want, and the case, the case is closed, is wrapped up. Your motion for default, your order for default, then you want to fill out the findings and conclusions, and then the final non-parent custody order. This non-parent custody order is what it says that the child is placed in your custody. And this is like the decree. This is the custody order itself. And then the residential schedule, this just states the residential schedule for the child. I mean, we'll go into that. So you've got 5 documents. Okay, so let's go to number 3, findings and conclusions. And again, that's non-parent form 430. And this is a big mouthful here. It's called Findings and Conclusions on Non-Parent Custody Petition. And basically, this is a document that sets forth all of the facts that are needed to get your final custody order. So these are the facts that the judge must find. And so what you're going to do is fill this form out, and you're going to check out the facts. You're going to check the boxes that indicate the facts in your case, so that the judge has the basis to grant or to sign the custody order. Now, paragraph 1, basis for findings and conclusions. So there's 3 ways you're going to be able to enter this document. By agreement, by default, which is what we're talking about today, and the default order. By default, you would fill in today's. I would fill in today's date, or the date that you hand the document, all the documents and the ex parte cover sheet to the clerk. I would fill that date in. It's okay, if the judge doesn't sign it till the next day. I think that the judge would be able to change that easily. You can always leave it blank if you want, but we're assuming that the judge is going to sign it the day that you hand all these papers to the clerk. But I think you're safe if you just don't fill it out at all. But you do want to check the box. Just don't fill in the date. And this is not going to be by trial, so you don't need to check that box. Okay, so moving to page 2, this is information about this is information about Indian children, and you have to pick the correct box there. Now, probably we're going to be assuming in this situation that you're going to check the box that says none, because that's a whole separate area of facts that we're not going to go into today. We're going to assume that this case involves a child or children that are not members of any tribe. So you would pick none. And then after you do that, it looks like page 2, paragraph 2, you're done with that. Number 3, again, we're on page 3, jurisdiction over Indian children. You're going to X out does not apply, because none of the children are Indian. Dependency case, you're going to check there is no open dependency case. And a dependency case is a case where CPS has filed a petition in juvenile court regarding the custody of the children. And we're going to assume that this situation, that CPS has not been involved, there is no other case pending. So we would check the box that says there is no open dependency. The jurisdiction, number 5, we're going to check the box that the judge can decide this case because the court does have jurisdiction over the children. So we check the box that says that this court can decide this case. The next page, on page 4, talks about the type of jurisdiction, and you've got a couple. You've got a number of different boxes here to check, and under most situations, you're going to check number 1, which is exclusive continuing jurisdiction, which means that the Washington court has already made a parenting plan or custody order for the children, and that being that's referring to the original temporary order that you got when you filed this petition. And again, we're operating on the belief that you, as the non-parent, you have custody of the child. Home state, the court can have home state if the child has lived in the state of Washington for more than 6 months. So you can check that one. You can check home state. You can check no home state or home state, that there is no home state or home state declined. I would not check that one under these circumstances. And other state decline, that's not appropriate. And temporary, you may want to check temporary emergency jurisdiction if in fact you came to court and you filed your temporary, you filed your petition for non-parent custody, and at that time you got like an emergency order that placed the children with you. You can check that one. Under most circumstances, if you're not sure, you're going to check the top one, exclusive continuing jurisdiction. Okay, number 6 is background records check. That is, you're going to leave this blank because the court is going to go and fill this out. The court will check the judicial information system. And so for paragraph 6, I would leave that, unchecked. 7, adequate cause. Now this is, you have to fill in the date when the court actually ruled that, okay, you can go forward with your case. We're gonna accept your petition for non-parental custody. We're going to let you move forward. So if there was ever a hearing like that, which we're talking about a default, so probably an adequate cause hearing was not heard, but if there was an adequate cause hearing, and again, I don't think that would be applicable in a default. So with a default, I would leave it blank. I would leave that blank. Number 8, are there valid reasons why the children should not live with a parent? And here is where you want to go to, you want to answer yes. At the time this case was filed, you want to check all that apply, that the children were not living with either parent, the children have been living with, you can put the other names and fill in the date, and that you also want to check that neither parent was a suitable custodian. And then on the bottom of page 5, on paragraph 8, the courts give you a number of lines there to, to fill out. You have space there to fill out why it's appropriate, why it's important, why it's necessary for the safety of the children that they, that they be with you, that they remain in your custody, and list the facts there why the parent or parents are unfit. So that is where you want to tell the court, why the parent is unfit. Maybe the parent has a substance problem. You can just put parent has a substance problem, parent has a domestic violence problem. But you want to put some facts in there. You want to detail some facts as to why it's so important for the children's safety that they be with you. And it needs to be, what you write in here should be focused around the parent. It's the parent's lack of ability to be able to parent the child. And so you want to focus on what it is with the parent. What are his or her faults or problems, issues? Why are they not able to parent? Number 9, you want to check yes, it's in the children's best interest to live with the petitioner. And you fill out basically the same reasons that you had put forth in paragraph 8. You know, whether that is that the parent has a substance problem, and is unable to parent because they haven't had treatment. It could be that they abandoned the child. It could be that they have a history of domestic violence and they haven't received treatment, or that they have sexually abused the child. So you would put that down there on number 9 under yes. And number 10, respondent's visitation. You have 2 choices: does not apply, or the visitation ordered is reasonable. In this situation, if you've got, if the parent is not visiting at all, you would want to put that down there under the box where it says the visitation ordered is reasonable. I would, let me back up for just a second. If you have an arrangement where the parent is visiting, you would want to check that box right there where it says the visitation order is reasonable. And even if they don't have a visitation, you still want to check that box, and you just want to say, this refers to your residential schedule. So that's number 5 form that we're going to fill out. You want to, this is a reference to number 5 form. So you want to check the visitation order is reasonable. So you want to check that one. If you check does not apply, the petition should be denied. That's a big legal error. You don't want to check that box. You want to check visitation order is reasonable. And that means the schedule here is reasonable. And number 11, it talks about any limitations on the residential schedule. Again, number 11, the first choice is does not apply. The petition should be denied. You don't want to check that. You want to read through these options and check what is applicable, reasonable in your circumstances. Moving along to 12, support, insurance, and taxes. If there is a child support order, you want to check that. Fill in the date when the child support order was signed. If there are health insurance arrangements, check that box. And if there is an administrative order, you should check the box that says so. And tax issues, you would, if there is a child support order that's been entered where the parents are giving you or are paying you a transfer payment each month to support the child, then you would want to check this and make sure that you either write something down that you're going to claim the child or children for during the tax year, or that you've made some arrangement with the parent where you're going to alternate claiming the child. And number 13 addresses a protection order. If you've asked for a protection order. So if you have, you want to fill in your name that says that you did. And if you have a protection order, here's where you would want to put in, that it was approved, and you can put the date. It was approved on a certain date. Now, if you're filing this along with a protection order, then that's a different fact pattern. But the way I read this part of the form is, it says protection order. No one requested an order for protection. More likely than not, that's the box that you're going to check, because if you feel the need for an order for protection, if you don't have it already under this case number, then you need to go and get it under a different case number, and you would check no one requested. You would check that one, no one requested it. Okay, so let's move on to, we're almost done this one. The restraining order, number 14, the same thing. We're now on page 8. No one requested a restraining order in this case. Okay, and now, again, if you do want a restraining order, then you would have to fill out a separate order for that, or yeah, you could fill out a separate order, and I can tell you the number for that if you want. And you know, when I go back here with respect to a protection order, so there's two different kinds of orders that they mention here, the protection order and then the restraining order. The protection order is typically, if you're going to request a protection order, then you would want to fill that out. Really, you want to fill out all of that. But given the nature of where you're at right now with this urgency at the end of the year, if you feel that you need a protection order, you should talk to the clerk and get the paperwork and fill out separate paperwork. I would not. I would skip this part for the protection order, and I would get the paperwork from the clerk and fill that separate paperwork out and get that in front of the judge according to what the clerk tells you to do. So, and 14, if you do want a restraining order, which is a lot different, you can prepare a separate restraining order that basically says you don't want the parent around the home, around the school, or around the daycare. You can prepare that, and you can file that along with your all of your documents and ask the judge to sign that. Number 15, I would check I would check each party should pay his or her own fees, or I guess if you want them to pay, if you want them to pay your costs, you can fill that in. It's going to be you'd have to be able to enforce that order, but really you can fill this out as you like. If there's a guardian ad litem, which there probably, if there is one, you'll want to check that so that they are discharged, that they're dismissed from the case. Okay, so you go to the very end, page 9, and you sign your name as the petitioner, and then you check the box is presented by me. Now, moving along to the next one, number 4. Okay, this is non-parent form 431, and it's called the final non-parent custody order. So this is the custody order. So this is when the judge signs this, you should make sure you get a certified copy of this order. Because this is will be actually the document that you would show third parties to say, I have custody, I have a court order, I have custody of this of little John, and here's the judge's order, here's the court order. And usually people third parties, if they're asking to see the order, more likely than not, you really want to have the force behind the order. And the only way to do that is you get a certified copy and you show that to them. So this is a document that you, after it's all filled out and the judge signs it, you want to ask the clerk for a certified copy. The first page has to do with money judgment. If there is one, just fill out what is appropriate there. If you want lawyer's fees, more likely than not, you don't have any because you're pro se. But if you had to pay a process server to serve them, you might want to put court service fees on the box there where it says other fees. And you fill in the amount. Okay, number 2, you fill out the child's name and age. 3, petitioner's authority. Then you would check probably box number 1, that there are no limits on your authority, that you're able to raise the children and make the decisions for them. Number 4 is respondent's visitation. And you would fill in the parent's name, and you would check if the parent does have some visits, some arrangement with you, you would check the first box. If there's no visitation whatsoever, you want to check the box that says no visitation, and you want to check the boxes that are applicable. Whether there's been neglect, child abuse, you have those various situations that you can check the box that's listed there that accurately describes the situation. Other respondents' visitation, and that would be if there's another parent. So if you've been able to serve both parents, then this would address the other parent. So if you just identify parent, parent 1 would be the first one, parent A, and then respondent, the other parent will be parent B. So you just put the other parent's name in there, and the same applies there, whether they have visitation or whether they don't have visitation. You check the box. And again, the support, insurance, taxes, you check the appropriate box there. If the situation's going to be that you either have a child support order associated with this non-parent custody case, or you have you don't have one. Now you can have one through the courts, or you can have one through the support enforcement, the state of Washington. So if you do have a support enforcement order, or you are asking the judge to sign a child support order, you want to check the appropriate box there to let the judge know. Okay, and health insurance, you can fill out the appropriate information there, what's going on. The same thing with the taxes. And again, it's somewhat mirroring the findings of fact that we filled out previously. So then at the end, there's money judgment and the protection order. Whether it's the protection order, we talked about that. If you really need a protection order under these situations, I would suggest that you go to the clerk's office for your own safety and ask the clerk what would be the best way to get the protection order, because you have to get there's a special process for that. For the restraining order, the situation is the same. And as I'm thinking this, when you filed your petition, when you filed your petition, you asked for a protection order, or you asked for a restraining order, you would fill out, yes, I asked for a restraining order at the very beginning of the case, and it was approved. So that would be when you would check approved. And the same thing goes for the protection order. It may be that when you filed the petition, you also requested a protection order at the same time. And if you did, then you would check there that it was approved, because if it was approved, you're going to have a copy of it, or whether it was denied. But that's I think the best way of interpreting those two paragraphs for the protection order and the restraining order. And again, if any of this situation that you're in right now, that you find yourself when you're doing this motion for default, if you think you need a restraining order, please go to the clerk's office and fill out the right paperwork. This is not more likely than not. If you don't already have an order that protects your safety, then you should ask the clerk so that you can get one. And guardian ad litem, there's more likely than not a guardian ad litem, so you would just check does not apply, and make sure that you sign down the bottom where it says petitioner signs, and you would check is presented by me. Okay, so then that's number 4. The last document is number 5, and this is the residential schedule. And the residential schedule, I highly recommend, I urge that you fill this document out. I consider it a necessity. You want to have this residential schedule in the court's file, because it'll, even if the non-parent isn't having any visitation at all and hasn't responded to this lawsuit, you still want to have a residential schedule that's signed by the court and says, no, the parents do not have visitation, or yes, they do have some visitation, and here are the limitations, and here are the days and times when they can see, when they can spend time with the child or children. These are the times when they can talk to them, or send, if they can, you would specify whether they can send letters. So this document, this residential schedule, even if they don't have any contact, it's important to fill this out. So you would start with number 1. You would check that this is a court order that's signed by the judge, and you would check final order. And then under that, it says you would check this is the final residential schedule. So there are 3 boxes there to check under paragraph 1. Custody, number 2, list the child's names. Number 3 is you would fill the parents' names in. Now, let's see, I'm going to just check and see if I believe that you would have, if there are 2 parents, you would have a residential schedule for each parent, particularly if there are unique situations to each parent. Let me just make sure here for just a second here. Limitations on visitation. I don't believe that this form is, let's see if it gives you a chance, if it is prepared so that you can fill it out for, let's see, for both parents, or whether you have to fill a separate one out for each parent. Okay, so reason for limiting a parent's visitation: A, you put the parent's name, and if there is any of these problems, I want to go back, make sure you know this is a non-parent form 405, and basically on this page, there's a list of issues that surround the parent. And you would check off those boxes that are appropriate. And if nothing applies, if there's no abandonment, neglect, child abuse, domestic violence, assault, sex offense, there's a box for other. And if you think that you need to check that box and add something, that would be the place to do it. Let's see. And it looks like, okay, it looks like, okay, all right. this, it looks to me like you have a place here for both parents. So so letter B here would be the other parent's name. So if you have the mother 3A and then father 3B. Okay, so that's what you would do. So now if you only have one parent, you just fill out 3A. You don't fill out 3B. But the same thing applies. Paragraph 4 has to do with the limitations. This is important to fill out based upon the unique circumstances of your situation. If you have supervised visits, then you would want to fill out the appropriate paragraphs here, the appropriate options where it says supervised visits. List the person's name, who's going to pay for it, whether that person's a professional or not. And you want to detail any rules that are specific during the visit. Whether the parent can take the child to the bathroom, whether the parent can prepare a meal. That's the place where you would write these details down. Now, if parent A has any of the situations that are in parent if they have any situations such as abandonment, neglect, child abuse, domestic violence, then you would check that if they don't have any visitation, you would check because of the limiting factors in 3A, this parent has visitation as follows, and you can put no visitation with the children. And again, if there is, you would check limited visitation and you would give the reasons below. Now, if this person has any problems with drug abuse or domestic violence, you might want to check the box there that says that you want this person to have an evaluation. And then you want them to provide a copy of the evaluation. If there aren't any specific limitations, then on page 4 at the top, you would check no limitations despite the reasons. And so you would fill out you would check the appropriate box there that says the parent's past conduct checked above did not affect the child or the children, or that the contact with the children will not cause them physical harm. So if you do check any of those issues like domestic violence, and you're not imposing any limitations, you want to explain, you want to pay attention to this paragraph right here and check that. If there are no, let's see, I think this is going back to, this is parent B. Okay, so this is parent B. That's if you have the second parent. So we'll skip that. That's sort of a repeat. And then when we get to page 5, this is the actual visitation schedule. And this is where you would fill out what kind of schedule. If the parents are going to have any contact or visits with the children, this is where you want to spend a lot of time. You want to fill this out so that it's clear what contact, if any, the parent's going to have. Now, if neither parent's going to have contact, you just check the box here that says skip the parent's visitation schedule. So you'd skip sections 5 through 8 if both parents have no contact with the other children. If you want to have a residential schedule or you want to have special visitation time, then you would want to check the box that says complete parents visitation schedule in sections 5 through 8. So from section 5 through 8, That really is the meat of the parenting of your residential schedule. It's divided by children under school age and school age children. And so this is, where you would, so for children under school age, there's a spot there for each parent's name. If the children are school age, there's a section for each parent's name, and you check the box that you have that you think is appropriate, or that you have already agreed to, or that you with the other parent. If you've spoken to the other parent and you've agreed to this, then you can, then you would fill out those times. Number 6 is the summer schedule. This is also, you can have the summer schedule be the very same as the school schedule, which is what you just filled out. Or you can have a completely different schedule for the summer. And under paragraph 6 is where you would fill that out. And there is a section devoted for each parent, where you designate the weekends or other days. And then paragraph 7 addresses the holiday schedule. And if there aren't any holidays, if you're not going to have any special holidays, then you check the box that says it's the same as the school schedule and the summer schedule. You would just skip this section 7. And let's see. And then so when you get to paragraph 7, that's where you get to all the boxes with all of these different holidays. And if the holiday does not apply to you, and you don't care, or there hasn't been an agreement made, just skip it. So if there isn't a midwinter break, or you don't have plans for spring break, you would just don't fill them out, just leave them blank. Same thing with Martin Luther King Day or President's Day. Those are usually Mondays. Mother's Day, and always on a Sunday. If you want the child to have any kind of contact or visit with the mother on Mother's Day, this is the place where you would fill that out and put down specifically the contact that you think is the best and would protect the child. Father's Day, the same thing applies. If you think that Father's Day always falls on a Sunday, if you think that it's important, you think that the children will be safe visiting with their father, then you would specify in that box. 4th of July, Labor Day, same thing. Thanksgiving, if this is a special time for you and your family, or for the parent or for the child, you can specify what type of a time they spend on Thanksgiving. If they do it in odd years or even years or every year, and you can put the specific time and date. Same thing for Christmas Eve and Christmas Day. If you're going to allow some special visitation for holidays, I highly recommend that if you do, and if you think it's safe, then you would take some time to think about Father's Day or Mother's Day. Take some time to think about Thanksgiving, if that's important, and Christmas Eve and Christmas Day. And then you would also want to fill out children's birthday, that section right there. And again, you fill out these sections if it's safe for the child to have any contact, if they can have any visiting time at all. If you think that the child will not be safe, then you're not going to get to this section. You're not going to be filling out sections 5 through 8. You're just not going to be filling these sections out. Okay, and on there's also a spot here where you have the holidays for other important occasions to families. So there's 2 boxes there where if there's something very important in your family, if there's a special religious day, this might be where you want to put in Easter, or you want to put in Hanukkah, or there's some Ramadan, anything, if there's something particular in your family, it could be anything that is observed by your family or that you think is important. I've had parents put in communion or confirmation. I've had them put those kind of special times in there. Easter. So if you think that is applicable, that would be the place, to where you would want to fill that out. So if the other parent has a special, time, and you think that they'll want it and you've agreed to it, you would put it there. And the same thing applies to you. If Easter is very important to you, you want to make sure that you put Easter there. If Halloween is your favorite, you want to make sure to include Halloween and put down that you're going to have Halloween, that the child's going to be with you every Halloween. This document is meant to be like your guidepost. It's something that you can refer to, and you fill it out to the very best that you can, so that you can refer to it in the future to avoid disputes. Number 9 talks about transportation arrangements, and that's where you put in if there's going to be any contact, who's going to drive the child? Where are you going to exchange the child? Is there somebody that absolutely cannot drive and provide transportation? You want to put that person's name there. If you want to meet at a public place, you put that down. Number 10, it addresses moving with the children, and this has to do with the relocation statute. And this applies. Let me just take a look here. Okay, for the number 10, it lays out in layman's terms, it lays out the requirements for the relocation that are written in the relocation statute. And it's very important that you read this and that you abide by this. And the situation I think that comes up the most is if they don't have any visitation at all, are you required to give them notice? And I think that it's hard to give advice on that from a general sense. Whenever there's any kind of statutory obligation with respect to the other parent, it's always best that you give them notice, even if they're not allowed to visit. It's the best thing to do because they are the other parent. Now, if there are really serious safety issues, then I would highly recommend that you maybe talk to the court facilitator, maybe get her input. The biggest priority is to make sure that the children are safe. And if you think that moving, if you are moving, and if you think that notifying the other parent is not going to be safe, it's not safe for the child, then you want to err on the side of caution and protecting the child. But on the other hand, if you have a parent that isn't violent and there isn't a real safety risk for the child, I would be inclined to just let them know. Again, this is a tough, this is a situation, it's a tough one. If you feel that they did not answer the petition, and you want to move, then I highly recommend that you, because of the new statutes that's coming into place, I would highly recommend that you talk to the court facilitator or call volunteer attorney services, or see if you can get a consult with another attorney. Find out what is best for your situation, because there's in family law, the best interest and safety of the children is always the priority. That is always your priority. And I think that if you know where the other parent actually lives and you know how to give them notice, and you are moving, I would probably talk to an attorney or court facilitator to find out if you should give them notice or not. Now that another attorney may not agree with that, but because we have constitutional rights involved, the parents have, when it's safe, have a right to know if you are moving, particularly if you're moving out of state. So when you're done all these documents, when you're done filling out all these papers, make sure that you make a copy for yourself, and make sure you have copies of all this for yourself. You want to take all of them and you want to go to the clerk's office and you want to hand her all these documents with the cover sheet. Don't forget the cover sheet. You just hand all of them to her, and when the judge has signed the documents for you, the clerk will notify you. And at that time, make sure, I would bring some extra money. I'd bring some cash with you when you go to pick up the papers, because you would want to get certified copies of these documents. If you can, afford certified copies of all of them, then I would do that. But I think their certified copies are expensive. So if you, the two priorities would be the residential schedule certified, and definitely the custody, the final non-parent custody order. That would be, if you only have money for one certified copy, that's the one to get. It will be a different world come January 1, when we no longer are following the non-parental custody statutes. We'll be under the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act. That's a mouthful. So we'll be under that act. If you have any questions at all regarding the non-parent custody situation that you have, and you feel your situation is unique, or if you feel that you've got questions that concern the safety of the children, there are resources for you to reach out, volunteer attorney services, and also definitely the court facilitator. He or she, it's usually a lady that's been working there, and she's awesome. She does an awesome job, and she can maybe give you some guidance. But if you just to summarize, if you have filed a non-parental custody petition, and there has been no notice of appearance filed by the other parent, no response filed by the other parent, after you have properly served the other parent, the non-parent, excuse me, the biological parents, if you've properly served the biological parents and more than 20 days has passed, if you serve them in the state of Washington, then you can go up and get this motion. You can file this motion, get an order for default, and enter all the final paperwork. If you served the biological parents and you served them out of state, and there's been no notice of appearance, no response to the petition filed, then, and you serve them out of state, and it's more than 60 days, then you have the basis to go up and get this order of default so that you can enter all the final documents. I hope that this helped, and it's been fun. I hope that this helps you. Don't forget the ex parte cover sheet. Don't forget that. That's really important. And because if you don't have that form, the clerk will definitely need it. If you don't know where to get it, don't worry. The clerk is there. She will give you a copy. So everyone at the clerk's office is there to help. They're friendly, and they will, if you don't have the document, they will give it to you. They will make sure that you have the cover sheet. Thank you very much, and I hope that this helped everyone, and good luck.